Court is calling 2024 CR 009936, State versus Carrie Lampkin. Are you Carrie Lampkin?
Yes, sir.
All right, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand if you'll state your name for the record.
Carrie Lanin.
All right, I'm going to ask you some questions, and the questions, thank you. The questions that I'm going to ask you are related to your representation. It's not about the facts of the case. If it were about the facts of the case, then the state would need to be here. Okay. This is just a determination of whether or not I find that you should be allowed to represent yourself, okay?
Okay, it's like qualique. This is a qualique.
A what?
Qualique, to see if I'm able to represent myself.
Yes.
Okay.
All right, so how far did you go in school?
I'm currently in school right now. Should be graduating next year, but now that I'm now getting behind with finals because of.
All right, so here's the thing. The best thing about being a witness and what attorneys always tell witnesses is just answer the question that's asked of you.
Okay.
So, how far are you in school?
I'm in college now.
All right, what year?
I'm considered a sophomore/junior.
All right, and what are you studying?
Law.
All right, and how many years have you studied the law?
I'll say about 5 years.
All right.
But it was in the civil litigation and family law. And
so, have you ever studied criminal law?
I never had a desire to learn about it until now that I'm going through this.
All right, so remember what I said, just answer the questions. Have you ever studied criminal law?
I've never studied criminal law, but based on my study, it's like all civil in nature.
All right, so here's my other question for you. Do you understand you have a right, because this is a criminal matter, you have a right to have an attorney appointed to you if you cannot afford to hire an attorney? Do you understand?
Yes, ma'am.
All right, so do you want to have one? Can you afford an attorney?
That's
yes or no?
At the moment, no, because of
all right, then the next question, here's the thing, just listen to the questions, all right? Are you able to afford to hire an attorney?
No.
All right. Would you like an attorney appointed to you? That's either yes or no.
But I'd be able to speak to counsel, like someone from my counsel, to be able to make a decision. I don't want to just rush and say yes and no when I don't.
No, I mean, here's the thing. You don't get a chance to choose who your attorney is. Yes. My question for you is, and I just want you to answer my questions. Yes, would you like to have an attorney appointed to represent you? That's either yes or no.
Your Honor, I'm sorry. I just feel like I'm being pressured and rushed, and I don't.
No, you're not being rushed. This case has been going on since January 2025. Let me explain something to you. When this case comes to trial, it is going to trial.
Yes,
there's not going to be at the last minute, I decided I don't want to do this. Let me get an attorney and get another reset. That's not going to happen. So my question to you is, do you want an attorney appointed to you? That's either yes or no. If your answer is no, whatever ends up happening, you end up representing yourself, then you're going to represent yourself. I'm not going to give any resets, because in the middle of trial, you decide you're over your head and you need an attorney. That's not going to happen.
Your Honor, with all due respect, my attorney,
here's the thing, don't start with all.
And there it is, the classic "with all due respect" line. In court, that's usually code for "I'm about to argue with the judge." But Judge Boyd, she cuts that off fast. This is what courtroom control looks like.
Due respect. And let me just tell you why. No. This is what I want to tell you. When people say "with all due respect," they're really getting upset. And usually what comes after "with all due respect" is not with respect. It's like when people say, "Let me be honest with you." Usually what's coming is not honesty.
I'm so sorry. I wasn't trying to go that route.
No problem.
I was just wanted to say with all respect, Your Honor, The reason why I withdrew from my attorney, there was an issue with discovery since day one when I
Okay,
hired
here's
him.
the thing.
Mhm.
I don't get into things about you and attorneys and what happened with your previous attorney
Mhm.
unless a previous attorney is here
I
to
understand.
give their side of things.
Yes. So, like again, Your Honor, so I'm not afforded my due process rights. I don't know. It's like to me, it's like you're making a judicial decision, and I don't.
It's not. It's either you want an attorney to represent you.
You nicely, Your Honor, if I could have some time to make that decision,
No.
because I don't want to make the right decision if I'm going to defend myself. I'm already lack of discovery.
My answer to you is no.
Yes.
If you want an attorney appointed to represent you, that attorney is going to be appointed today. You're going to meet them today. If you don't want an attorney appointed to you, then one will not be appointed to you. And your next setting is going to be a jury trial. And when you come in, it's going to trial. That's where we are. And I'm going to tell you again,
Mhm.
Previously, when you were saying you were filing your bill of particulars,
Yes.
I am not going to be an attorney for you. I'm not going to show you how things legally should be done or the legal process, because the last time you were here, I was helping you with your motion to say, is this what you mean? I'm not going to do that anymore. I'm just going to look at your motion. And if your motion is not in the proper order, if your motion is not asking for appropriate things, it's just.
This is the moment most pro se defendants don't see coming. Judges are neutral umpires, not coaches. She's spelling it out. I won't guide you, I won't help you, and if you mess up, it's on you. Brutal honesty, but also legally airtight.
It's going to be denied. So it's not going to be my job to walk you through questioning of witnesses. I'm assuming if this goes to trial, the state is going to call witnesses.
Okay.
Not going to be my job to help you cross-examine them. It's not going to be my job to teach you the rules of evidence or criminal procedure. That's going to be all on you. And if you're not following those rules and the state objects, and it is an appropriate objection, then it's going to be sustained.
Yeah, I'm not asking for any legal advice or.
You have been, though, because the motions that you've been filing have not been appropriate motions. Your bill of particulars, when I read it, it's really not a bill of particulars.
Like, I'm trying to be respectful as possible, Your Honor, but you're applying pressure on me to make a decision, and everything is moving fastly. Like, I don't consent to go to jury when my due process has been violated. I'm praying that you can hear me out, but it seems like you're pushing me into making a decision without.
No, so let me just explain something to you. Your attorney was here at the last hearing. Your attorney said that he's already shown you all discovery and you've received that. And here's the thing, you're saying that's not true.
I have substantial evidence, Your Honor.
But listen to me, put on your listening ears.
Yes, ma'am.
This is what I'm telling you. Your attorney, the attorney that you hired.
I didn't hire him.
Your attorney.
I didn't hire him.
Your attorney said that they gave you all the discovery. Sometimes people receive discovery and they don't like what they're seeing. That's fine. That attorney is a good attorney.
Mm-hmm.
That attorney has not had any violations, no ethical concerns by this court or by the state bar. That attorney said that you had already received all of the discovery. That attorney even has a portal on his website where his clients can go in and look at the discovery that he's received. He said that you've already received that. So you're coming to me saying that you.
And here's the collision. The defendant says no discovery. The attorney says everything's delivered. Judges have a simple rule: they trust official records, not stories. If you're pro se, that gap can bury your defense before trial even begins.
You haven't received discovery. Your attorney says you have.
Yeah.
So, no, let me stop you there. So what I am telling you is this is going to trial, and you're standing before me saying that you have not received discovery when your defense attorney says, I have given you the discovery and I have no reason to disbelieve your attorney. Your attorney has never given this court any reason to disbelieve him when he says that you have received discovery.
Mm-hmm.
their question, and this is the last time I'm going to ask it, and you can answer it. If you don't want to answer it, that's fine. This case has been on the docket since January. What I am telling you right now is you will answer yes or no. If you don't want to answer it, you don't have to answer it. Do you want an attorney appointed to you? Yes or no?
I'm under pressure. I don't understand.
All right, that'll be no.
Being
Ms.
respectful.
Ferguson, place this on the jury trial with Judge Angelini on June 16th.
So I'm not able to talk, Your Honor.
Sure, you can talk. Go ahead.
So I have placed on the record, Your Honor, substantiating evidence of the proof that I have not been able to receive discovery. On May the 3rd, May the 3rd, I have received an email of some more discovery that my attorney sent me after I filed a motion to withdraw from him. The only reason why I filed this motion to withdraw from him is because of the lack of discovery since day one. You know, Your Honor, every time we came here, it was, oh, Your Honor, the file's too big. Oh, Your Honor, I don't have, I haven't got it from Jason. Oh, Your Honor, he has to come in and buy a hard drive. Like, he made me as his client get a hard drive to go get it, and he still didn't give it to me in a hard drive. Your Honor, I have substantiated evidence to prove my facts, and I have submitted it. I have filed it in the clerk with the clerk. So if he's willing to say what he said to you in court, that he sent me discovery, I would love, Your Honor, if he could do a sworn affidavit statement stating what he said, so it could be put into.
He's an officer of the court, so he doesn't have to do a sworn affidavit.
Yes, I understand, but I put the burden of proof. I showed the burden of proof, Your Honor, of my facts. I'm showing you that I did not receive discovery until Saturday, 2 days before trial, 2 days before court date hearing. If you can look in the system, you'll see an affidavit statement signed by a notary that I signed under perjury, under sworn. I swore in, and under perjury. I'm not trying to go to jail over lying. I'm telling the truth, Your Honor. He did not give me discovery until it was a Saturday. That Saturday before court. And it's big. It's a big file. And how could you miss that? Yes, he did send some before, but he's piecemealed, Your Honor. 1 month, 2 months out, 2 weeks after that, in 1 month after that. It's like he's been piecemealing this stuff to me. And then he says that, oh, the file's too big. And this would make me make the decision to withdraw from counsel because he's not the best fit for me. Maybe he's a good attorney, but he's not probably the good fit for me. And this would make me want to represent myself because I wanted an attorney. But after I went through 6 months with dealing with him, and I was very patient, very patient. I didn't say a word.
This is where frustration meets legal reality. He's angry about the plea deal and discovery delays, and honestly, many defendants feel this way. But here's the cold truth. Feelings don't outweigh signed receipts, and the jury won't care about this speech.
Get upset with him. He wanted me to take a plea deal before I even got discovery. And that's what really made me, not upset, but made me a little concerned because I'm like, you're representing me, but you want me to take a plea deal without me having discovery? Like, where's my due process rights? Mm-hmm. You know, that's a violation of my due process rights. I need to be able to defend myself. I cannot defend myself properly if I don't have all the evidence in front of me. Mm-hmm. That's all I've been trying to say.
Your acknowledgement of discovery was signed, that discovery was received on April 14th. Ms. Ferguson, could you have somebody from the state come down, please? And if you'll give him a reset form for June 16th.
Well, Your Honor, you're denying the fact that we have to go into jury without my due process for the record. I just want to know, Your Honor.
I'm giving you extra time. That's why it's June 16th.
Yes, ma'am.